delegate to the United Nations working group seeking to create a global online mechanism for resolution of consumers and businesses e-contract disputes. Fourth, we'll hear from Charles Knapp. Professor Chuck Knapp is a graduate of New York University School of Law, where he got his JD, and Denison University, where he got his BA. He came to UC Hastings in 1998 from NYU Law School, where he had been a faculty member since 1964 and was the Max Greenberg Professor of Contract Law there. Prior to his teaching career, Chuck was associated with Paul Weiss in New York City. And our commentator for the panel is Peter Linzer from Houston Law Center. Is he down there? There he is. Okay. Peter received his BA from Cornell and his JD from Columbia. A former editor of the Columbia Law Review, Professor Linzer joined the Houston Law Center faculty in 1984. Before going into teaching, he practiced law both as a Wall Street lawyer and as an assistant corporation counsel for the City of New York. Professor Linzer is a member of the American Law Institute. He's a noted scholar on contract law. He's published 2 editions of his A Contracts Anthology, with the 3rd edition planned for publication. Wait, for the fall of 2009 market.
Yeah, that thing's pretty much died.
Okay.
Yeah.
Oh, died or done? Okay. Anyway, he served as the editorial advisor of the Restatement Section of Contracts. Okay, so again, we begin with Danny Hart.
So I also want to add my thanks to Jennifer Martin, and who's not here, but thank her and St. Thomas and all the law review students who I understand had to spend the last couple of days of their spring break here sitting with all of us and making sure we could get from room to room and otherwise not lose ourselves on campus. So I really do want to thank everybody, all the students and all the organizers for this really wonderful conference. What I want to do really quickly before I jump into my talk is kind of put my talk and the whole panel into perspective. And then I'll explain what I'm going to talk about. But so our panel is called Contract Law and Social Justice, and we query whether or not that's an oxymoron, because what we're really wondering is whether contract law has a role, if any, at times of growing inequality and acute economic crisis. And I'm just reading from the description that we had submitted to Jennifer Martin. Classical contract law provides only a minimal response to this question, presupposing, as it does, a belief in the sanctity of contracts that requires strict enforcement with very limited exceptions. Because contract law in this view is private law, this view denies any association of contract law with goals related to social justice. So our goal on this panel is to explore the relationship between contract law, the state, and social justice by critically engaging with the practical and theoretical challenges that emerge from imagining that contract law as an arm of the state might in fact be playing an active role in the public sphere. So the focus of my particular talk is to take issue with the myth that the state is absent or its role is minimal and neutral in the field of contract law. And in fact, my argument is that contract law is actually public law, not private law. And this is true for 2 reasons. Let me see if I can get the clicker to work. Yay. So in fact, contract law is public law, not private law. First, because the state's role in the field is neither neutral nor minimal. And second, contract law is public law because contract law in action helps to create and perpetuate inequality in American society. So why it matters? Why does it matter whether or not contract law is public law? Well, in the first instance, I just think that contract law is public law more accurately reflects reality. And perhaps counterintuitively, though, let me just state up front that the fact that I think contract law is public law really isn't some radical idea on its way to becoming a solution to society's ills or to even an unmaking of contract law, because I don't think contract law is going to go away, nor do I think every contract is in need of a remedy. That said, I still do think that contract law is public law, and exposing that particular truth and the role that it plays in society, I think, matters, because only if we see contract law as public law do I think that we can meaningfully reform contract law in a way that will mitigate its impact on society. To do that, though, to even begin the discussion of how to mitigate any harms we think contract law may be having or causing in society, I think we have to shift the frame from which we understand and analyze contract law. So in other words, once we see contract law as public law, I think that we can then shift the frame from an individual autonomy and liberty frame to an equality frame or some other norm that we decide we like better. So I'm going to be using a hypothetical during my talk to help illustrate the points that I'm going to be making. The hypothetical is one that I think is very familiar to most people, having come through the Great Recession. So here's my hypothetical. In 2006, City Mortgage sold Mary Smith, a 32-year-old African-American woman, a subprime loan to purchase a single-family residence in a predominantly minority neighborhood in exchange for a mortgage on the house. City Mortgage sells Ms. Smith, or sold Ms. Smith this loan, even though she didn't actually qualify it. Some of the terms included in the loan included things that I think we're all familiar with, again, from having lived through it: high prepayment penalty provisions, high origination and post-origination fees totaling about 20% of the loan, and a 228 adjustable rate mortgage. City Mortgage did comply with all the relevant consumer protection laws, but did not disclose to Ms. Smith that she did not qualify for the loan. 2 years later, Ms. Smith defaults on her loan. Now, I chose City Mortgage because it's part of, it's a subsidiary of Citigroup, and because it was one of the biggest subprime mortgage lenders in the country. Mary Smith, I came up with Mary Smith based on research and studies that showed subprime lending was made predominantly to younger, primarily single or divorced women of color living in minority neighborhoods, and that African American women were disproportionately represented among that particular demographic. But to get now to the crux of my argument. Contract law is public, and I'm going to focus in the first instance on the role of the state. Contract law is public because the state's role is neither minimal or neutral. Why? Because the state helped to manufacture the desire for home ownership. The state created the residential housing market. The state decides enforcement issues, and of course the state enforces judgment. So with respect to the first part of it, the state helped manufacture the desire for home ownership, particularly after World War II, through its rhetoric that it used for decades to promote home ownership as the American dream, through regulations and policies, explicit regulations and policies it put into place to encourage and facilitate home ownership, and by making home ownership the better option. So rhetoric, and I'm going to talk about this section really quickly. My colleague Hila Keren is coming out with a paper that covers some of this rhetoric that helped manufacture the desire for home ownership in a forthcoming paper, so I'm just going to touch on it. So rhetoric. U.S. presidents from Hoover through George W. Bush promoted home ownership as a central part of the American dream. So Roosevelt in the 1930s said a nation of homeowners is unconquerable. Bush in the 2000s made it a point to challenge the real estate and mortgage finance industries to encourage them to join the effort to close the gap between home ownership rates of minorities and non-minorities. So again, there was this consistent, decades-long push just in terms of rhetoric from U.S. presidents promoting the idea of home ownership. There were also regulations and policies that were put into place that privileged home ownership in the form of single-family dwellings. So through the creation of Fannie Mae, Freddie Mac, Veterans Administration, the FHA, we adopted different regulations and or policies that included minimum plot sizes, that included zoning preferences, preferring ownership over renting, the underwriting of single-family home mortgages by the FAA as opposed to underwriting other communal and cooperative housing projects. And of course, we all know that the FHA ultimately adopted a more flexible long-term fixed-rate mortgage that primarily went to whites. So again, I think rhetoric plus regulations and policies help manufacture the desire, but then also the state helped manufacture the desire by making home ownership the better option, right? So we're all probably familiar with permitting the deduction for the home mortgage and equity loan interest rate payments, and permitting deductions for state and local real property taxes through the code, Internal Revenue Code. The second way I think that the state is the second reason that I want to talk about is that through the regulation and deregulation, the state also creates, in this instance, the residential housing market, okay? I have a series of slides that I'm going to show you, and when I say I'm going to show them to you, I mean that very literally. I'm not going to let you read them because it's just really there to show or highlight a point, right? Through regulation and deregulation, and the slides that I have only focus on federal. On federal regulation and deregulation, the state created the residential housing market. So starting back in 1863, notice it's going on, and this isn't all of them either. This is just a sampling of the regulation that we had. This is just a sample of the deregulation that we had, and this particular slide is simply shows you there's a federal regulator, a state regulator that regulates all the banks. So again, the point is that through regulation and deregulation, the state created the residential housing market. We also know that the state decides enforcement issues with respect to contracts, whether to enforce or not to enforce. It may or may not come as a surprise to some of you that in the context of mortgage cases, the courts have held that the lenders owe no fiduciary duties to borrowers, that they have no duty to disclose whether borrowers actually qualify for the loans that they sold, have no duty to refrain from making loans to borrowers whom the lenders know can't repay the loan, and of course have no duty to give borrowers the best rate. But bottom line here, the state decides all the enforcement questions, and as we all know, ultimately the state is going to enforce judgments that the courts end up rendering. So with all of that in mind, I think my first point here is that contract law is public, because the role of the state in this field is neither neutral nor minimal. I think it's extensive. But more than that, I think contract law is public law because contract law in action helps to create, and let me emphasize again, helps to create and perpetuate inequality in American society. And this is how I think it works. It starts from the premise that the parties aren't equal. As we all know, the starting point in my understanding is property ownership. With very, very few exceptions, the state originally limited property ownership to straight white men, and since then there's been a myriad of laws and legal regimes, including but not limited to segregation, immigration, and education, that ensured that the original unequal distribution of wealth, of property specifically, would continue and become an entrenched part of the American social fabric. The realists told us over 85 years ago that what one owns determines one's bargaining power in the market and ultimately determines what one will be able to acquire. Contract law basically ignores this structural inequality, this decidedly uneven playing field. The bargaining power that you come to the contract table with is not taken into account by contract law. And I want to point out here that the structural inequality in the form of unequal bargaining power that contract law ignores is not limited to consumer contracts or the contract boilerplate. I think structural inequality in the form of unequal bargaining power is present, is ignored by contract law in most instances, regardless of the parties involved or the type of contract at issue. And the structural inequality is not taken into account because contract law applies the same set of rules to everyone, regardless of the context. So whether it's a business versus a business, whether it's a business versus an individual or an individual versus an individual, the rules apply to everybody. So the point that I really want to emphasize here is that if we just change the rules with respect to some kinds of contracts involving some types of parties, this is going to ignore what I think is the structural inequality that's built into the contract law system, and that the structural inequality exists anytime there's unequal bargaining power between the parties. And I think that exists in probably just about every contract. So when you impose the same set of rules on the parties, I think, and here I'm talking obviously about contract law, the likelihood is that the stronger party is going to come out ahead. And I think that the reason for this is because it's very, very easy to get into a contract, very, very hard to get out. So easy in simply means, contract law only has two elements. Contract law requires mutual assent and consideration to form a contract. Neither of those elements are very hard to satisfy in practice at all. If these elements are satisfied, then contract law is going to presume that you have a valid contract. There will be a presumption of contract validity in your favor, and from that point on, it's really, really hard to get out of a contract for reasons that I've called elsewhere the process problem. I'll talk about them very briefly. The first problem here is that the burden to rebut the presumption that the contract is valid is on the party that no longer wants to perform, meaning the party that wants to get out of it. Rebutting the presumption, I think, is extremely hard to do because contract law imposes the burden on the party challenging the contract or defending the breach of contract action to show that the contract is unenforceable or no longer needs to be performed. All of the doctrines that you might want to use to challenge the validity of the contract still presupposes that the contract is valid in the first instance, right? You can only get to it after you get past formation. And of course, there are several practical realities that make getting out of a contract really hard. So starting with some work that Eric Zaks is doing on contract design, the way we design our contracts first and foremost. Will the harmed party even be willing or able to complain. This is some of Amy Schmitz's work that I'm sure she'll talk about later. Getting an attorney to take the case, especially if you have small claims, very, very difficult. There's limits, ongoing limitations on legal service providers like legal aid. They still can't do class actions. The costs of litigation in general are going to be prohibitive. There's also changes in civil procedure. And I don't know how many people in the room are familiar with the changes, but there's a series of cases, right? Twombly, Iqbal, and Walmart versus Dukes that impose heightened pleading standards to even get into court, easier standards to get out of under a motion to dismiss once you're in court, and of course, the Walmart versus Dukes case, which reinterpreted the rules on class actions that makes it harder to have them. We also know Bill Woodward's work on this has been very informative for me, right? The pervasive use of certain contract clauses, choice of law, choice of forum, not to mention the arbitration clauses that we've heard so much about, and class action waivers, right? That are prevalent as well. And of course, we know that courts are reluctant under most circumstances to let parties out of their contracts regardless of the legal excuse that they raise. So Larry D. Matteo's empirical work on unconscionability, of course, bears that particular claim out. So remember that I said, given contract law in action, the likelihood is that the stronger party is going to come out ahead, and this is how I think it works. Everything starts with property, which is something the state determines what those property rights are. Property rights then determine your bargaining power in the market, which contract law ignores. The party with more bargaining power is usually able to dictate contract terms, which means that the stronger contracting party can reap more gains from each contract than it otherwise would with less bargaining power at its disposal. The vast majority of contracts are going to be binding, and as a result, the state's going to enforce them, even if bargaining power is abused. So making contracts binding basically ensures that the party with more bargaining power will get to keep the gains from each of its contracts, and so over time what you have is that the party with more bargaining power will end up with owning more land, more labor, more resources, both tangible and intangible, which means that it ends up with even more bargaining power, and so on and on. I want to pause here just for a second and have you take a look at the chart. And the reason I want you to take a look at this chart is because the diagram doesn't depend on a misuse of bargaining power. It doesn't depend on a misuse of bargaining power. It doesn't depend on a bad bargain or whether consumers are at issue or we're using boilerplate. I think the diagram represents how contract law in general works. So in other words, the argument that I make that contract law helps to perpetuate inequality isn't limited to just those contracts in which bargaining power is abused or there's some kind of undue advantage taking. I think it's a function of the system as a whole. You start with more, you end up with more. The stark example that I started with, which was the mortgage, the subprime mortgage, let me just give you some real broad brush statistics. So this is what happened, This is what happened to Citigroup. So Citi Mortgage is a subsidiary of Citigroup. I couldn't find specific stats on Citi Mortgage, but this is just a slide that shows you what happened to Citigroup before, during, and after the Great Recession. So Citigroup, I think, is doing really fine, in case anybody is worried. Let's compare that to Mary Smith. Mary Smith, the primary source, the studies all show, right, that the primary source of wealth for African Americans and Latinos was their homes. It's their homes. And so in 2007 to 2009, there were 2.5 million homes that were foreclosed. Whites, 4.5%, 7.9, 7.7. These are the numbers that were foreclosed. I did not find the specific number for whites, but I think the point here is that blacks and whites, blacks and Latinos were 70% more likely to lose their homes. And so when we talk about Mary Smith, in 2009, there is a Pew Research study that said, right, the average wealth of a white household, you might have seen these numbers previously, was over 113,000, blacks are about 5,600, Hispanics are about 63, and the primary reason for the discrepancy or the disparity is the decline in home values, which again, to bring it back around, was the mortgage. It's a contract, okay, it's a contract. And so again, just to illustrate, right, we're going to have disparities there. I want to take just a minute, my last minute, to talk about what the implications are, because obviously, I don't think contract law is solely responsible for creating or let alone sustaining inequality in American society, because it's not. But that contract law plays a role at all in this process is important, I think, for several reasons. First, I think just about no one ever thinks about contract laws having anything whatsoever to do with inequality. People usually think of con law, employment discrimination, and things like that, when in reality, a lot of the work with respect to inequality on a day-to-day basis, I think, takes place in the context of contract law. I don't know anything about torts, sorry, I'm just leaving that on the side, okay? But I think a lot of the work on a day-to-day basis takes place in contract law, and I think we ignore that reality to our detriment. I think it shows, I think the fact that contract law plays a role here at law shows that Maine's assertion that progressive society moved from status to contract is simply wrong. On the contrary, I think that we've moved from contract back to status, assuming we ever left it, such that individual potential in American society, one more second, is determined by one's class status rather than by one's contract. Last point, the very fact that contract law produces social consequences, meaning inequality, underscores the point that the distinction between private law, where individual freedom reigns, and public law, where the state can justifiably exert control, simply doesn't exist, which is why you come back full circle. So contract law, the core of the so-called private law system, is actually public law. Thank you. Okay, let me find yours. Yours is Schmitz. Is it this one? Must be this one.
No,
That's not yours.
No.
That's right. Sorry, I see Schmitz. Yours.
I think maybe this,
Oh, okay,
because mine is usually blue.
okay.
No.
Nope. Okay, sorry, we're just having trouble finding the slides that we need.
I'm having a scare.
Gibson, Florida. Oh, there, with this one.
Yes.
Sorry.
So where, how do you get that? All right.
And then your thing works, your clicker works.
Okay. Wow, that was a relief. Hi, everybody. Thank you for staying after lunch. And I want to open with a positive statement. I know often when I listen to Danny's compelling argument, I personally get somewhat depressed because if this is all that we're doing in contract law, that's really bad. And the question to me and the topic that I want to engage is what can be done. So I hope that it won't be that depressing. I think there are certain things that we can do. We have a lot of work to do. So the lot of work to do is the topic of my talk. How do you go?
Just forget, yeah.
You just did it.
It's working. Here, let's see.
And enter doesn't work. Uh-oh. Do you know what's going on?
No, because it was working. And it's on.
So the presentation is on.
It's on.
I'm sorry. Can I hit escape and maybe enter it again? But it doesn't work. Okay.
Just press this button, see if that works. Yeah.
Okay.
Okay, good.
All right. So as you see on the slide, my starting point is a favorite quote of mine by Roy Kreitner, who said, "Contract law is a mode of social regulation whose rules ought to serve social goals." So that's where I begin. I believe in that statement. And from that, I want to ask and take it further to say, well, we ought to do this, but I think that we are, as we heard from Danny, we're far from doing it in a specific kind of a way. So I want to talk about the pattern in that. And then I want to ask and focus on the question of how can we change that, that we're not doing the good job that we're supposed to do. And I want to make 3 points. And the points is that if we want to make things different, we need to change our theory. We need an alternative theory. We then need to think about substantive norm that we're going to follow that is missing right now, and then we need to figure out legal tools. Now, for the most part, I'm going to leave the legal tools to Professor Knapp, who's going to talk a lot about unconscionability. I'm going to just touch on that, but this is the roadmap of what I'm planning to do. So first of all, to slightly zooming into this, why are we doing a bad job? I think that we're doing bad job mainly if the contract is unfair, predatory, and bad. Let me take one example and then I'll give another one. So in the context of predatory prenups, here is a real story, so that's not a hypo. The wife also asserts that the fact that she found herself a pregnant single mother, I want you to pay attention to that, presented with an agreement shortly before her scheduled wedding date and being told that if she did not sign, there would be no wedding, is by its very nature coercive. So this is an argument coming from a party to a contract. The court is saying those factors cannot be said to have divested the wife or her free will in the terms of the agreement, where if the terms were unsatisfactory, she was free not to marry. So this is something that I want to talk more about, the freedom not to marry. Now, this is not just one example. Professor Martha Ertmann has pointed out the current state of the law creates a moral hazard, allowing richer spouses to use prenuptial agreements to take unfair advantage of their poorer spouses. This is, as of itself, a topic for a paper, but what I want to say is that we see here a pattern of exploitation in the market and via the tool of contracts. Another one is the one that Danny touched on in the context of predatory loan agreements. I just want to focus on this one little side quote from the court. A jury might well conclude that the borrowers were targeted not on the basis of being African American, but because they were vulnerable, low income, unsophisticated, first-time home buyers who happened to be African American. So this is another trick, something we do not too well, not well enough, where we say, well, maybe there is a problem, but this is not a contract law problem. So if you can prove something under anti-discrimination laws, then maybe go there, go to public law. But here, we have nothing to say about it, although my question and my answer will come, what about if it wasn't because they were African Americans, but just, quote unquote, because they were vulnerable, low income, unsophisticated, first time, so that makes it okay? Are we okay with that? So I think this is really a problem, and I think this is another known to the public pattern of exploitation. So based on those two examples, I want to raise a broader question. How do we link that to the question of social justice? Let's say that contract law is not only public, but really shaping the market, the one institution that is required, that without contract law you have no market. So that's one thing to remember. And it is operated for the most part by judges, and then, or not the most part, but for large part by judges, and then a judge faces a question of how should I respond to an argument of exploitation, coming from a wife-to-be, coming from a borrower, coming from someone who feels that they were exploited. Now there are two typical possibilities. One of them is not to respond and not to intervene, and the other one is to intervene and to protect the exploited party. So these are the two possibilities. The result of taking the first path is actually to increase inequalities, and the result of taking the second part is to decrease the inequalities. Now, sadly, I agree with Danny that what's happening today is that more courts are taking this path of no response, no intervention, and therefore increasing inequalities by way of making the powerful get stronger and the powerless get weaker, so we're doing bad things. From now on, it will become more, what can we do, okay? So the goal, I think, is to move from this path to a path of intervention, protection, and decreasing inequality as a link to contributing something to social justice. So that's contract law contributing to social justice if we can find and justify a way of intervention and protection. Now, I hate the word intervention, and I will talk about it in a minute and replace it with another word, but I just wanted to use the familiar terms. So, first thing that I want to do is to consider switching theory, okay? And I will compare right now where we are, I believe, is, let's see if it works here. We're under a neoliberal paradigm, and I think we need a paradigm shift. We need to switch theory, and I want to consider what do we mean when we talk about equality under the neoliberal theory versus other theory. What do we mean by who's the subject of that, and what's the role of the state in that? Now, I have a name for the alternative theory, and it's vulnerability, and I'm drawing here on the vulnerability theory developed by Professor Martin Feynman. I have an asterisk there because I don't 100% agree, and I also want to allude to the fact that this theory is not a newborn, but in many ways continuation, to my mind, of older theories, and has a lot to do with feminism, queer theory, and a lot of other critical race studies, and a lot of other theories that were more identity-based. But I will just mark it here, because, and if you want to ask about it in the Q&A, I'll be happy to talk about it. So under the neoliberal paradigm, equality equals no discrimination. So it's formal, and I don't really need to add more, because after we had all listened to Robin West this lunchtime, so that's the concept. And however, alternative theory really requires that we will see it as a right, and the right is to be equally valued individual, to have our own dignity, and I would add what we heard over lunch, part of participation in civil society. I think it all goes hand in hand. The subject at the core of the neoliberal paradigm is this private, autonomous, capable of making choices, solely liable for bad results creature. We have talked about this creature all along this conference. However, in reality, I don't think we are that. We are all somewhat, to a degree and in different kind of ways, vulnerable. And most important, we are interconnected. We're not that isolated, neither from each other, but nor from our communities, our state, our society. The economy goes up and down, we go up and down. So it's not that isolated. And what's the role of the state? According to the neoliberal paradigm, it's nothing. It's the state is a big threat. It's something bad. This is intervention, right? It really threatens to invade our privacy, to take our freedom in the natural, kind of sense, and therefore we should do minimal intervention. However, under alternative theory, the state is accountable because the state created some of it. It permits other parts of it. And the state should be not intervening, but responsive, meaning caring about all that, involved in social justice, and therefore I said I hate intervention. I would rather see the state being responsive rather than threatening anything in this story. What is the new norm that I want to talk about or instill if the state is about to respond, according to which norm? I think what we need is to realize that to be vulnerable is a normal thing. It's not something that is saved for someone on food stamps that we need to kind of turn our head away from. And it's a human condition, and it's not an exception, right? So the next step is to really realize how vulnerability is connected to policies that are public, to the political condition, and to the state. So it's not just one person's fault that they are vulnerable. This is a result of something much larger and much more complex. And the third point, think about the pregnant wife-to-be who just could avoid the prenup by not marrying. She is living in a country where single mothers are singled out, where they're stigmatized as being not making the right choices, with no health services, with no preschool on a public kind of a way. So the choice is really informed or impaired by the situation that is so social, right? And therefore, exploitation of this kind of vulnerability is harming to something in us, the human dignity that we have, and a responsive state, and that's the main point that I was leading at, a responsive state should treat, via contracts and contract law, they're both instruments, and therefore a responsive state should say those instruments that I give you cannot be abused, and they cannot be exploited, and you cannot use them to exploit vulnerability. So that's the bottom line. The norm is a norm against exploitation of vulnerability by use of contractual tools coming to the state to say, hey, now enforce that. And this is a right. What I want to see is a right not to be exploited by contracts due to vulnerability, which will be a contractual right that contract law is going to protect. Now, there is a precedent, or there are precedents in the plural to something like that, and I just, again, like Danny, you don't have to read, but this is how it looks in Europe, right? You can phrase it that there is a right to not to exploit, and the right, the way it's done in Europe, is comprised of the party that is vulnerable, but also the behavior of the party who is exploiting. So the party that is dependent, the party that has economic distress, the party that has an urgent need, those are that are inexperienced, and it can hit us in many points in life. Of course, some people suffer more than one kind of vulnerability, and while at the same time the other party knew or could have been expected to have known this and exploited the first party's situation by taking excessive benefit or unfair advantage. So this is one way to word this norm of anti-exploitation, and we could have, in an ideal kind of political world, maybe legislate that, right? Copy from Europe, right? I don't know that it's possible, and this is why I want to make the third step and talk about one legal tool that is available currently, although I think misunderstood, underused, and Professor Knapp is going to say more about it. But I think in the current political situation, assuming, and maybe I'm assuming wrong, I'm open to talk about it, assuming that we cannot legislate that or put it in the restatement and have states accept that, I would think that we can still do something by using and utilizing utilizing the doctrine of unconscionability. Now I realize that I skip a point. What is the role of the responsive state in this situation after switching theory, acknowledging a right not to exploit? What is the role of the responsive state? If one has a right not to be exploited, there should be a matching duty of the state not to enforce exploitive contracts. Without such a duty, there is no content to the right not to be exploited. And this is where we get into contract law, and by seeing more or facilitating more refusals of the state to enforce the exploitive contracts that result from the breach of the right not to be exploited. How should we do this? For one thing, as I explained, we can utilize unconscionability. Under the known procedural prong of unconscionability, we can take into account the vulnerability of the exploited party. We can think about a pregnant woman. We can think about last-minute cancellation of a wedding. We can think about African-American person who is not earning enough money to afford buying a house, being convinced and pushed to doing so. And we can think about other signs, those that I earlier referred to as patterns of exploitation. And then under the same procedural prong, we can take into account, and we should take into account, the sharp techniques of the exploiting parties, and they're doing horrible things, such as raising the prenup just at the very last minute before the wedding, knowing that this will be a critical moment, and as opposed to what the judge said, it won't be that easy to just not marry in a situation like that. So I think that we can take all that into account under the procedural prong, and we have a very nuanced, context-based way of doing it, and it can be sensitive and should be sensitive to how extreme things were. So there is a lot of work to be done here. And of course, as under any analysis of unconscionability case, we can put the predatory nature of the contract right under the substantive prong of unconscionability, where we'll ask how predatory and unfair the contract is. So if the contract transfers all the wealth accumulated during marriage to the husband and takes any marital rights from the wife, we have one way of referring to how unfair the contract is. If the terms of the loan agreement are horrible and terrible, we have ways of documenting that, and eventually a judge can come to the conclusion of whether or not that was unconscionable. Now, okay, yeah, I'll finish on that. All right, so this is the framework. This is what is available if you take an alternative theory, a norm that establishes a right not to be exploited, a matching duty not to enforce exploitative contracts, and then using this legal tool of unconscionability. Now, you can all ask, and I'm sure some of you will ask, isn't this intervention, right? Wow, because this goes so much against all these classical ideas of invasion of privacy. So I think that a good starting point, and I'll let Professor Knapp continue from there, is something that Professor Mel Eisenberg often reminds people. So in his forthcoming book, he's saying, under the unconscionability doctrine, the government forbids nothing and commands nothing. So that's great reminding that he continues. It simply says to the promisee, if you can accomplish your ends without our assistance, fine. I don't think it's fine, but fine in terms of law, right? But don't ask us to help you recover a pound of flesh. So this is how the state can be more responsive. Thank you.
Pointed towards something?
I think just vaguely in that direction.
Okay. Hello. First of all, just thank you so much to the conference organizers and to Professor Martin and Danny and my fellow panelists. This is really good and important stuff to be discussing and thinking about justice in contract law. And we think about contracts, and I've done some different research, and for those who wanted the kind of empirical data behind some of what I'm going to be talking about, it's in the Pepperdine Law Review article, and it's on SSRN, so anybody who is more interested in the statistics, as it were. So what am I going to talk about? Well, I'm talking about access to consumer remedies in the squeaky wheel system. I mean, we're all familiar with the squeaky wheel. But how many are there? How many of the squeaky wheels, meaning how many consumers actually have the requisite resources, the requisite confidence, the requisite information to actually pursue their rights? Now, we in this room are sophisticated consumers. I mean, we're probably the type of people who are going to call up the company when the product breaks. You would not believe how rare that is. It is very, very rare. Roughly 1/3 of consumers take any action at all, okay? We also know that it's very few of those consumers that go the extra mile, meaning out of that 1/3, there are very few that then actually make the phone call, write the letter, and keep going in order to get a remedy. Meanwhile, the vast majority of consumers are underwater. We're not getting remedies. It's more and more difficult, and companies know this, right? I mean, that's why they have the arbitration clauses and the class waivers for small dollar claims. It doesn't really make it worth your while. So why would you go the next mile? And if you're not a sophisticated consumer, if you don't have the sufficient information and the requisite resources, you probably aren't going to, I mean, you might not even speak English well or have difficulty actually filing those kinds of complaints. Another study showed that out of 1,000 purchases, and this just shows the gap, in the highest status, highest financial status category, 98.9% of those purchases of 1,000 will they actually complain about. Compare that with 60.7 for those in the lower status. we end up with the squeaky wheel system, or as I like to call it, the squeaky wheel system in B2C, business to consumer contracts. Lots of things going on here. Many different propensities, behavioral and otherwise, and economic, that are coming into play. We don't squeak, meaning we aren't likely, as I was saying, there's few of these individuals. We might not even be aware of our rights. Inertia comes into play, right? It's that having to go that extra mile that's just too difficult. Over-optimism. We go into things, we make that purchase, and we want it to go well, right? So you don't want to admit that you made a bad decision, and you usually end up, I know I do, blaming myself, like, oh, it's my own fault, you know, just suck it up, and you don't end up actually going out and getting a remedy. Rule following. It's been shown also that we like to follow rules. You don't want to be the bad kid, right? Resource and patience limitations, enough said. Socialization and biases as well come into play. The research does show that women are less likely to ask. You know, you sort of grow up with different propensities, for example. Now, compare that now. Companies have an impetus to grease the wheels, meaning pay off the few squeaky wheels who keep on pursuing their rights. Pay them off. Why? Because then, first of all, you're rationing your remedies to only those individuals and not to the public at large. You're retaining the best customers. It also turns out that it's interesting because the research shows that people who've had complaints and were appeased are more loyal than somebody who never had a complaint. Quieted claims. Well, if you're sort of paying off, even if you look at Hill versus Gateway, the famous case, they tried to sort of pay them off so they wouldn't lead a class action. But this is, because we might argue, and I get that. I understand the thought that, well, aren't you just rewarding responsible consumers? I mean, if you are that consumer that is proactive, that puts your time and resources into pursuing your rights, then shouldn't you just be able to get those remedies and you're just properly getting the remedies you want? Well, the problem with that is there's concerning consequences. The theorists say that there's this informed minority, right? The argument being that even if the majority of individuals don't read their contracts or pursue their rights, there'll be this informed minority that'll go out and then tell everybody else about these problems, and then we'll all vote with our feet and the market is going to work nicely. Well, the problem is that if the squeaky wheels are being stifled, they're not playing that role. It stymies market regulation, resulting in under-enforcement of consumer protections, especially with the Magnuson-Moss Warranty Act when you think about consumer purchases. And contractual discrimination between the haves and have-nots. And it's bolstered with bias when it's combined with big data, which is the next iteration of my research looking at how big data creates discriminatory contracting situations. And we don't have time for that here, so I'll keep going. So who does squeak, right? Who does squeak? Well, a Consumer Reports study showed that 58% of those earning over $50,000 versus 43% of those earning less say they will bargain at all. Similarly, 71.3% of female versus 53.4% of male respondents in my own empirical study that I did said that they never or rarely try to negotiate. So we also see that people are getting different deals. And it's subtle sometimes, but there's the Ayers study that he did a study of Chicago car sales. And the big sort of punchline that comes out of it is that white female consumers had to pay 40% higher prices than the white male consumers. And they had controlled for everybody sort of wearing the same outfits and having the same socioeconomic status. Black consumers ended up paying 2 times greater markup than anybody else, than any other consumers. The Consumer Federation of America, they did a study on the subprime market. Interestingly, again, with people having the same economic portfolios, the upper income black women were 5 times more likely than the white men to end up with subprime mortgages. One professor asked, well, why would people who could qualify for prime mortgage loans end up with subprime loans? That's worrisome. Is it just benign business or is it bias? It's interesting once you kind of go out, and I like to just read everything and just go out, look at the economic literature, the marketing literature, they don't even hide it. They'll say that, well, to some extent, all marketing and all contracting is allowed to be discriminatory, because it just is. We can choose who we're going to contract with, that being the theory. So in my study, in looking at how fair you view different contracts, and this, I'm going to go through these quickly, and you can see, but the idea being, it shows how irrelevant and how we're sort of no longer, we've given up a lot of hope in our contracts, right? And so in my study, what was interesting is the thing out of all these different kinds of terms, the consumers said usually or completely fair at the highest percentage for warranties. Company standard form contracts came into second place. Contracts with family, contracts with friends, not as much trust. Loan contracts and sales contracts, ironically, they actually think are more fair than with your friends and family. What came into last place was the dispute or claim settlement agreements. That was in last place. Once only gym memberships were seen as, yeah. Also, they had what kind of terms are important when it comes to a complaint, showing how we don't go back and we don't actually rely on our contract rights even when it comes to a purchase problem. Now, the purple bar, those are the no's. The purple bar, that's the no. And if you notice, what is it that people think is least important when a complaint arises? Arbitration clauses. But that's tremendously important when you have a dispute. Again, asked, how often do you even try to change contract terms? How inert are we, right? You have 65% saying never or rarely. Of that percentage within that part of the pie, 71.3% of those were female versus the 53.4% were male. There's also that. Some people just won't ask out of fear of rejection. I know I'm guilty of that. Also, out of the people who had tried to change purchase terms, how often have you been successful in getting terms changed? Well, you see, it's only 16% said frequently or nearly all the time. I don't know if you've ever done that little experiment where you try to ask to change a term in a contract and you have the person saying, this happened to me with DirecTV, I just wanted to see what he would do when he was at my house installing it, and I said, I want to get rid of that arbitration clause in there. And the guy looks at me, I'm sorry, ma'am, then he was like flabbergasted by that idea. If you have been successful, what types of terms have you been able to change? Well, you see, that's out of the very few people. So out of the 306 people that were in my survey, there's only 29 that actually said that they frequently or nearly all the time try to change. And then out of that, there was very few that have been successful, right? We see arbitration requirements at the highest for no. What is your level of agreement with the following statements? 66% said they strongly or somewhat agree that they assume they cannot change contracts. We feel powerless. Similarly, do we rely, again, do we go back and look at our contracts when we have a purchase problem? Well, asked their level of agreement with whether they go back, whether they've read their contracts since having a purchase problem. Again, we see only 31% saying strongly or somewhat agree. Only going back and reading it after you, I mean, I can understand somebody maybe at the front end doesn't read their contract, they're too busy, but they will actually, very few actually go back and read the contract. We don't turn to contracts when trouble arises. How often do you read? Again, similar statistics. We've given up. We don't read our contracts, especially regarding remedies. We don't trust contracts, especially settlements or anything having to do with getting a remedy. We don't seem to care a whole lot about our contracts, especially when it comes to arbitration terms. And we don't negotiate, especially if you're somebody who is disempowered. And we're not relying on terms when complaints arise. So what are we going to do about it? I don't want to just sort of leave us depressed and thinking the sky is falling, we don't care about contracts, we got no rights, and we're all just sort of like left with nothing, right? So instead, what I want to do is I want to introduce, and this is going to be the next iteration, and I talk more about this in the essay that's going to be in the law review here, and thinking about how can we bring back responsibility. I mean, it's hard to make people read their contracts. I know, I don't have time, I'm not going to go and but how do we bring back remedies? How do we make it relevant? How do we bring back the handshake? I'm from a small town in the Midwest, and you go out and you go to the farm stand and you shake hands with the farmer, and you know that's their trust mark. It's their, you know they're good for it. If the corn is bad, I go back to that stand, and then that farmer knows I'm going to keep coming back because he gives me some new corn if the corn is bad, right? It's the idea of a handshake. We don't have that with e-contracting. So what I'd like to introduce is the new handshake to ignite justice in business to consumer contracting. So the idea that we can bring back that corporate responsibility, bringing back a responsibility to consumers while helping both consumers and companies through what? Online dispute resolution. And I've been looking at this issue, online dispute resolution, wrote an article a long, long time ago thinking, oh, this is the wave of the future, it's gonna happen, it's gonna happen, it's happened. It has not happened to the extent that we had predicted at that time. Why? Because it's not being done right. It's too complicated, it's insecure, there's a lot of difficulties. Although it has had some fits and spurts, and certainly in the European Union, they passed a directive and they're getting it going, and we're working on it through UNCITRAL at the United Nations for cross-border disputes. So this is something, hopefully, that can happen. So build a field of dreams, right? What are we gonna do? We're gonna capitalize on the different things. Low cost, user-friendly, convenient and flexible communications. Imagine if you are the busy single mom and you can file your complaint in your pajamas or taking care of your kid, or you're working all day and so then you could get this done at night. And in a non-intimidating manner. Using different technologies and techniques. I mean, people are all wired. I mean, everybody in here is. Interactive and satisfying processes that give consumers choice along the way. It's been shown, the research does show, that when an individual has choice, Zev, who spoke yesterday, looks into some of the empirical data on that it really improves your willingness to comply. So what are the different types? Well, we've got problem diagnosis, direct negotiation, mediation, online arbitration. There's also crowdsource, this idea of restorative justice online. Right now, eBay's got that going on. But what I want to introduce now in my last minute here is this example process then for B2C contracts. How can we create this system? And there's a lot to be worked out, and we're kind of working on the different ways it can be contextualized and can be geared toward different kinds of disputes, and there's movement in this direction. Imagine if you have a central ODR website via a linked trust mark that's featured on each of the merchants who buy into this process. Consumers.org, right? And it's like a trust mark. It's your personal, it's your handshake. The merchant then earns the right to post that trust mark by opting into the system, and they deposit some funds into this, right, to help make it run. But it'll be worth their while because they're going to save money in resolving those disputes. Moreover, you're going to want to go buy from them because you know that you have a remedy if something goes wrong. This is particularly good for international e-contracting when you're afraid of contracting with certain developing nations because you don't know what sort of remedies you'll be able to get if things go awry. First step, the buyer, when they've got a problem, they go to this central website, they could click right from that trust mark picture, and they can report the problem through this process. And the seller responds, the buyer can choose the different courses here of the taking the remedy that's offered, mediation, and finally it would go to arbitration. Really quickly, and I know my time is up, But just to add really quickly, a couple other kind of special features of it is the fact that there is a trigger mechanism, and that's new. And the idea being that when a requisite number of similar complaints against the same kind of company are instigated, then people like the CFPB would be alerted that there's a real problem here. So we're giving public voice and consumer protections. And so it's that idea that the trigger mechanism, when you really know, and this can be good for companies too. The marketing literature shows that they actually want the feedback and to know when their products are breaking. It's better if that happens sooner rather than later, and to ward off class actions. Key considerations, there we go, and I'm way over budget here, and we're seeking solutions, addressing the contractual discrimination and market failure caused by the squeaky wheel system, providing access to remedies for all individuals. Picture it's like guided TurboTax for disputes. Advance enforcement of consumer protections, augment efficiency and fairness for companies and consumers. Thank you, and if you want more information, you can go to my faculty page at University of Colorado. Thank you so much.
I think they're going to hire me to do AV and tech although no one in their right mind would really want to do that, but, okay, hold on, let me.
Okay. First, we have to see if this works. Is that? No.
Oh, it has to go there.
Yeah, you gotta move this over here, right? Oh, there it is. Yeah. Is it even moderately legible? Maybe. Okay. I apologize for the lack of tech. We were lectured yesterday about people who are digital natives and digital immigrants. I'm the grandpa who stayed back in the old country while the young folks came to the news, so I get a cell phone call once in a while, but otherwise I'm isolated from a lot of stuff. Okay, let me explain what this is and what this is not. This is not a paper. This is not very ambitious. It may not be very important, but it's part of a longer or a larger project. It's sort of a progress report, if you will. Several years ago, I stumbled sort of latterly, I guess, on the intersection of mandatory arbitration and contract law. And I had the feeling that maybe other contracts teachers were as ignorant about that as I was. This was sort of just beginning to happen. So I wrote at that point, this is shameless self-promotion, but I don't think it's only that, so forgive me. I wrote an article in the Fordham Law Review basically waving my hands and saying, this is awful, do you realize this is happening, pay attention, people. So that was sort of the first step. And then as mandatory arbitration, as the law of mandatory arbitration developed, it became clear that I guess I should be talking into this, shouldn't I? Not into the light. Okay, sorry for it became clear that one of the relatively few legal devices that could be used to resist mandatory arbitration was the notion of unconscionability. So with the help of some research assistants, I started collecting, meaning they started to collecting, while I smiled and said good work, a lot of cases on unconscionability over a couple of decades. And out of that came not as much as should have, but at least another article, which is the blowing the whistle article. The thesis, and there are copies of this out on the table, by the way, if anybody wants to pick one up. The thesis of which is that as unconscionability was invoked more frequently by courts in the context of mandatory arbitration, that courts maybe would get more used to working with it, and maybe lawyers would think of using it more, and maybe would play a more important role, because as you all probably know, it had come to be seen as a sort of backwater or a subsidiary, one of the things, it's a base you have to touch in the contracts course, but the lawyers and judges really don't care anything about it, was I think a lot of people thought. So our thesis was that over the 2 decades from 1990 to 2010, roughly, that there had, did I go away? Did the thing go away? No, okay. Maybe my ear did. That there had been a substantial increase in the number of unconscionability cases generally, that the lion's share of that increase was certainly due to mandatory arbitration, but that there was at least some perceptible increase maybe in non-arbitration unconscionability cases. These are cases where courts either actually upheld some kind of unconscionability claim or at least said the motion to dismiss should be denied, at least this should go to a trier of fact, which we saw as some kind of a victory in terms of the legal, the process of a lawsuit. So that's the San Diego article. And then a couple of years ago, I was happy enough to be part of a project in Sheffield that produced an anthology of chapters, including one, mine was on unconscionability in American contract law, which is available online if you rummage around for it a little bit. So I have put the name of my research assistant along mine at the top of the outline, because he is as much, if not more, responsible than I for what you see and what I'm talking about here. He graduated from almost said NYU. Oops. He graduated from Hastings a couple of years ago, and is a practicing lawyer now. I still hope that he and I will be able to collaborate a little bit and bring more of this stuff together. Okay, let me then substitute. Does that show? Okay. This is kind of a report of just the cases in 2010. It's a little old now, but nevertheless, what we found was, what he found mainly, was something like, I don't have the number here. Why don't I? Yes, did I? Yeah, well, there it is. I'm sorry. Yeah, I'm looking at the wrong page. So let me look at what you're looking at. The types of cases. 59 cases doesn't seem like much, but if you look at the concentration, you have some land sale cases, even fewer land lease cases, a whole bunch of mortgage lending cases, and a whole-ish bunch, not quite as many, money lending, meaning not secured lending, but nevertheless, mostly consumer lending, and a fair sampling of sales of goods and some leasing. Some of that is equipment leasing, sale leaseback sort of thing. A few construction and repair cases. Only one service case, which is, I think, an alarm system, oddly enough. A few that we call finance, which are sort of hard to categorize. Not very many employment cases, and the ones that are there are not particularly what you would think of as the paradigmatic employer oppressing employee kind of situation. They're more nuanced than that. And finally, a whole clutch of domestic relations cases, where what's at stake is typically either a prenup or a property settlement agreement, division of property at the time of the divorce. So, moving along, here is that there? Yes. This is not very scientific list, but it may be the most important thing that I'm going to try to say here today, that of the various issues that are at stake here in these cases, many of them have what we think of as a traditional unconscionability analysis, procedural, substantive, absent meaningful choice, so forth, so forth. Some use other definitions. But, you know, there are a fair number of courts doing that, and part of my point here is courts know how to do this. You know, it's not like, oh, you're asking the court to do something unheard of. Gee, that's really strange. There's a formula for this, just like there's a formula for anything else. And most courts have case law on their books, and they can look and they say, oh, yes, it's procedural substantive, or they may say it's sliding scale, or they may say it can be one or the other instead of both. But basically, it's not anything that out of the ordinary for them. A couple of those there. One of those under number 1, time of evaluation of unconscionability. We traditionally say it has to be at the time of the making of the contract. The case that says we'll evaluate it at the time of enforcement is a divorce settlement agreement or a prenup. In other words, is this operating unfairly at the time that we're being asked to enforce it, as opposed to the time it was made. Okay, then run your eye down the rest of that page. I think it's all pretty much on the one page. Look at the doctrines: equitable estoppel, liquidated damages, unilateral mistake. The restatement rule specifically refers to unconscionability, which you may remember. Constructive trust, constructive fraud, statute of frauds, lots of unjust enrichment cases, reasonable expectations, unclean hands. I shouldn't read them because it's the deadly thing to do when you're using a projected screen, but my point, and I do have one, is it isn't just a 2302 procedural substantive, is this an unconscionable contract device. It crops up all the time, right? Unconscionability is a kind of thing that courts are asked to look for in the context of a lot of different doctrines, and they're used to looking for it. Some of them are more likely to see it than others, but it's not like it's any surprise to them. And so I guess part of my message here is it's much more pervasive and important in a small way, if that isn't too oxymoronic. It's much more pervasive than maybe you think. You know, it's one of the ways that courts think about not just refusing to enforce contracts sort of in a broad gauge way, but applying and dealing with lots of other legal doctrines that they're asked to use. Also important, I think, I hope, is the number of statutes, cases involving statutory violations of one sort or another, in which a discussion of unconscionable, I'm going to say unconscionableness, because when you say unconscionability, you sort of conjure up, 2302, and Williams against Walker Thomas, and, you know, Arthur Leff, and all of that stuff. Discussion of unconscionableness. There are federal statutes there. I don't even know what the first acronym stands for. I forget. I'm sure all of you know, but I don't. But the point is, those federal statutes and all the state ones that follow, I think, I won't say without exception, but I think I can say for the most part, those are statutes that expressly use the term unconscionable. You know, so it's not just in the UCC, and it's not. I say this partly because, you know, we tend to say, oh, well, we could never have any statutory law that would do anything like that. Well, we have it already. We have all kinds of statutes that refer to unconscionable behavior or unconscionable practices or unconscionable, you know, outcomes. So this is a dozen or so states. Granted, it's not all 50 states, but 12 states is a lot of states. And in all those cases, courts didn't seem surprised or uncomfortable to be asked to talk about unconscionability in the context of deciding those cases. What am I up to in terms of time? Okay. All right. I have a few, let's see. I don't want to go through all of these. They take too much time, but checking account overdraft case, a case that against a whole bunch of banks produced a multi-million-dollar settlement agreement. Don't think that unconscionability doesn't have some utility to practicing lawyers. It also is the case that, to me, is remarkable for the court insisting that unconscionability can be an affirmative cause of action. It isn't just a shield. It's a sword as well. Yep. What? Yeah, it's in our book, which I don't want to dwell on it at long length, but here's a case. The Park case on the bottom here is notable to me for the number of statutes that the court refers to, and this is a New Jersey case that also cites and relies on Kugler against Romaine, which some of you may know, which is a very old New Jersey first generation unconscionability case, and it's the plaintiffs speak only Korean. Shades of star credit. There's another wave of people who don't speak English, and they're being asked to make contracts in the English language too. Let's see. There are a lot of mortgage refinance schemes through here, in which courts have responded to very readily. There's a. I'm sorry. Yeah, this case, Emmert, the whole discussion of unconscionability in this case is this. The parties agree that Wisconsin law recognizes both procedural and substantive unconscionability. Plaintiff's allegations permit an inference of both types. Plaintiff alleged that Countrywide Bank took advantage of them by drafting the agreement, not giving them enough time to review it, and failing to disclose all of its provisions. Plaintiffs also alleged that the loan documents were unfair and misleading in a number of ways, including by misrepresenting the nature of the interest that they would be required to pay, period. Thus, plaintiffs allege enough to support an inference that defendant is liable for the conduct alleged. 12 lines, very simple. The court says, look at this, we see it, and we have no trouble with this at all. So it's happening, and I think it will continue to happen. And I'd like to use my last couple of minutes this is mainly for Deb Post, but anybody else who wants to listen is welcome to. I came to your talk yesterday, right? And I'm not a very graphic person, right? So I thought I should have some graphics. So I was thinking about wisdom for me tends to be found in places like The Wizard of Oz, which is so cliched that everybody knows all that. But the early Disney movies, I think, are also useful. So here are just a few. Everybody knows this image, right? Snow White is mainly about if you're lucky enough to meet a prince and marry him, you can grow up to be the queen. That's fine as far as it goes. But the real wisdom in Snow White is don't take candy from strangers. Right? That's perfectly obvious. It's an apple, but the principle could not be clearer. Bambi, this is a big four of the early Disney movies. Bambi also has the, if your father's a king, then you can grow up to be a king too, which is nice. But the main bit of wisdom in Bambi is here. When Thumper says, if you can't say something nice, don't say anything. Right? I think academics, can take that to heart, just like everybody else in the world. That's wisdom. You know this one, right? This is Dumbo. He's flying with the magic feather, and he's about to panic, and Timothy is about to say, no, you could fly all along. It wasn't the feather. You had the power to succeed within you. Okay, that's good. Good wisdom that kids should know. And this is the fourth, and for our purposes, the only really germane one. We know who this is, right? This is Pinocchio. Pinocchio is meeting Jiminy Cricket. He's surprised because Jiminy Cricket is a conscience, and Pinocchio has never had one. So, here's another picture. Pinocchio is happier because he's getting used to his conscience, and they're starting to communicate with each other, okay? My view of unconscionability has come in the last week or two, as I worried over this, sort of down to this. Let me at least get to the end of my paragraph, and then I'll stop. Things like reasonable expectations and good faith and other doctrines you can characterize in other ways. But if you look up the dictionary definition of unconscionable, almost everyone begins by saying not restrained by conscience. And my thesis is that we need judges who have consciences. I didn't realize I was going to have to use the plural, but judges with conscience, right? It's not, we talk about having a government of laws, not of men or not of people. It's not enough. We have to have a government of good laws, but also of good people. We have to have judges with consciences who are willing to use them. And that's why I think the word unconscionable crops up more than we think it does, because it makes a point. Lots of individuals don't have consciences, and if you'll permit me to say it, corporations clearly don't have consciences. Courts have to supply those. So good luck to them. Thank you.
I'm supposed to talk about our speakers and also have a few minutes for myself in this thing. I'm given 12 minutes. And I'd like to begin by, first of all, saying to all of you, talk to your the people who have your travel budgets and tell them to put time aside so you can go to San Francisco next October, because Hastings is having a symposium about Chuck in honor of Chuck's 50th year in teaching. And it's going to be good, and it's for Chuck. And we've all learned...
Chuck won't talk, but Peter will, so that's
another point, yeah. But on the same topic, by the way, it's contracts and politics. It's the same topic as we have here today, contracts and social justice. We've all learned so much from Chuck, and I did want to make the point that this was very interesting, because this talk that he just gave, because come to feel that unconscionability is kind of like a great 60s, 70s topic that's sort of run its course. And Chuck showing us that there are 59 examples of recent stuff is very useful. I think an important thing with respect to that is that Art Leff, who was an incredibly brilliant guy, but was misused, I think, in many ways by people, and of course died so, he killed himself with cigarettes and he died so young. And we don't know where it would have gone, but he took this notion of unconscionability and turned it into a technical notion. It's got to be both procedural and substantive. As far as I'm concerned, unconscionability and the word unconscionable means it smells bad. And I think that's what Chuck was getting at. That is that the term was used, hundreds of years ago, and basically meaning this is no good. And that's a useful thing if it's going to go anyplace. As far as contracts as a matter of public law, there's no doubt in my mind that that is true. I don't think it's just public law. I don't think contracts totally distort our nation. I don't buy into that. But it is true. And it was pointed out brilliantly by Morris Cohen in 1933 at the end of the Hoover administration in his great article, The Basis of Contract. Gene Braucher wrote a very important article in 1990 called Contracts and Contractarianism. You have this conflict between the notion of contract as this thing between two people and everybody should stay out, and contracts that have an impact on all of us. Contract is an awfully useful device, and there are aspects that do justify it as private lawmaking. You can do things that legislation can't do because it's two people and they can twist things, they can tailor things and so forth. But that's a very idealized view, of the farmer and the two people doing this thing. We know that that's not what's involved. We know that our adhesion contracts are the great dominant thing in our culture right now, affect people much more than any other contracts. And because of e-commerce, adhesion contracts have become much more important than they used to be. Because you used to go in and buy a book by walking into the store, taking it off a shelf, handing it to the clerk and handing him $5, back when books cost $5, but handing with cash. Today, you go online, governed by the thing that you clicked on with Google, go to Amazon's site, governed by the thing you clicked on with Amazon, buy the thing, maybe from a third party who has a thing you click on, and then it's delivered to you, and you pay for it with a credit card. Again, either you clicked on it or they sent you a little booklet which basically says we can change the terms anytime we want. And all these things are there. Now, it seems to me that the arguments that have been made here, I think Amy's argument about the online, making your claim online and getting into mediation, things like that, is fine. I've got nothing against it. I'm skeptical that businesses are going to fall over their feet to get involved in this thing. I think some will, and that's really good. I've been told, for example, that Home Depot does better than Lowe's because it has makes more money in things because it has an easier return policy. And when people return things at Home Depot and are treated very well, get their money back and so forth, they go back there. And I've been told that Lowe's doesn't do that. I don't know. I've dealt with Home Depot. I haven't dealt with Lowe's. Walmart has a good policy too. They're pretty good on returns. So I don't know. I think there's a lot to be said for business, that good business and decent business is also smart business. But unfortunately, not everybody buys into that, and we know that. And the question is what we can do about it. I think that some of the arguments have been, I'm not going to go into the question of whether adhesion contracts are good or bad. As far as I'm concerned, they're terrible, but we can't get rid of them. You can't go to the direct TV installer and negotiate with them. Do you want to run a business that has your contracts negotiated by the guy who plugs the thing in the wall? You can't do it. You need something. What can we do about it? We could do things like have presumptive unconscionability, which is what Todd Rakoff said many years ago, or a burden against the dominant party, or presumptions, reasonable expectations. All these things require the consumer to go to court. And we've been told for years by people like Stuart McCauley and Gene Browker, they're not going to do it, and if they do it, they're going to lose out because of the questions of economies of scale and the question that the dominant parties are repeat players, et cetera, et cetera. My answer is, and this is where we move into my thing to some extent, I say ban things. Now, the EU has started that, and I'm told that France has done it even more than the EU. The EU has what's called a black list and a gray list. I looked at the blacklist yesterday, and it seems to me the blacklist is all about fraudulent practices, that it's not really saying you can't have an arbitration clause. I'm told that, however, that France has stronger things on some regs. As far as I'm concerned, this is something. I'm not saying get rid of unconscionability or anything else. They're great, but they're not enough. As far as I'm concerned, I would like to see someone, and I'll get into who in just 30 seconds, for example, ban pre-dispute arbitration clauses in consumer contracts, ban distant choice of forum clauses, possibly ban all or some consequential bans on consequential damages, things like this. And then there are others that probably are more modest, and maybe you should have something they can do it, but not if, they always kind of, for example, with choice of forum clauses, well, mom and pop can't go all over the country to defend. Yeah, but Microsoft can. Why do you have to go to Washington State to sue Microsoft? They can be in every state in the union. But who's going to do this? Well, the Federal Trade Commission did this 30 years ago, 40 years ago, when they banned the holder in due course doctrine in consumer transactions, which used to mean when you got the defective product and the chaseman, we'll assume that it's not Bernie's finance company, which is the brother-in-law of the guy who sold it. Even if we assume that one, that we could knock out, but litigation expensive. He sells it to the Chase. Now the Chase comes around and says, we got your paper, and you say, but it doesn't work, and the Chase says, we're a holder in due course. Federal Trade Commission says, no, you're not. Get rid of it, it's gone. It's been gone for 40 years. Nobody remembers it anymore. The Consumer Finance Protection Bureau is clearly the idea to go. Of course, it was the product of our former colleague, Elizabeth Warren, who many of us knew and the rest of us know of. Well, I decided that this is a great idea, and I had my library get out Title 10 of the Dodd-Frank law, which set it up, and this is Title 10. It's 181 pages long. It basically says we're not turning you into a general consumer bureau. You can only do it for finance, and it says you can't do, and then has 4 pages of exceptions of what you can do. I've been working through it. It's horribly legalistic and federal, but there are things there, and they can do a lot of these things, and they can do it by administrative regulation. And one thing that they've been given that nobody seems to know about is Section 1078, in which Congress gave the Consumer Financial Protection Bureau, admittedly only with respect to things that can somehow be tied to credit, but fairly broadly, the power to modify or ban all pre-dispute arbitration clauses. They were told, start an inquiry, and let Congress know about it. That's worth nothing. But it goes on and says, after you've done the inquiry, if it justifies it, and they're doing the inquiry, you can ban it or modify it. They've already started that process. This changes the whole thing that we teach about, pre-dispute clauses. A federal agency can get rid of these things. As far as I'm concerned, that's the way to go. I'm not saying it's the only way, but I think it's more effective because it evens out the scale questions, doesn't rely on the goodwill of anybody, and I think can make some real progress in an area that's really important. For the last thing, the idea that is contract really part of public law? Are consumer contracts part of it? Consumer spending was 71% of the gross domestic product in 2010. 71% of the gross domestic product. How can anybody say that that's not a matter of national importance, even without getting into notions of right and wrong or anything like that? Just in pure numbers, it's damned important. That's what I got to say.
That
judges can say, if you're asking me to enforce this, I cannot stop, my conscience won't allow me to do that. And if enough judges say that, then legislatures, federal or state, will begin maybe, or regulatory bodies, will begin to say, well, yeah, maybe this is something that needs a systematic look rather than just a series of visceral reactions.
I just want to follow up and say that I agree, and I think that I'm very, very, very much agree with the idea of judges using their conscience to say things like that as an alert. And I also worry that by the fact that a lot of judges are not doing it by following the paradigm that is pretty much dictated by law and economic analysis of there is no point of using it, unconscionability doesn't fit here. The same idea of the best thing to do is to separate morality and conscience from legal analysis, particularly in contract law. So there is a stream of significant body of decisions that say the opposite of it. So I would rather see more of those to function the way you are suggesting, rather than to see all those judges that are actually too afraid to touch that and are convinced by rhetoric suggested mainly, I think, by Judge Posner, but he relies on Holmes, and this idea of this legal analysis has nothing to do with morality and it's a good thing, right? But in order to really serve the function that you're talking about, we have to hear the stories, we have to have a conscience. The judge that says, you know, we're not going to help you. Something in the spirit of what Melage is already saying. If you did it and I haven't seen it, that's one thing. But now that as a judge I'm sitting and I'm witnessing this horrible story, I'm not going to enforce that in order to really enable other processes that maybe are more democratic or more thoughtful to really start. So this is the particular way in which we should go. But currently, I think the resistance is coming from the other theory that it has nothing to do with unconscionability and conscience.
Just a footnote, just this instant, I remember that Jiminy Cricket's song in Pinocchio is "Give a Little Whistle," which of course is the theory. You blow the whistle and somebody will come.
Yes.
Just following up on Mary's comments, it's not bargaining power in these individual cases usually, and I still maintain that it is impossible for a court post hoc to assess bargaining power. I don't care if it's Facebook versus me or Facebook versus Mrs. Williams. We can make a guess, but we can never be certain on it. But what bargaining power is useful as a concept is not regulating individual cases, but as serving as a contract only works where both parties have some recognizable bargaining power, and where courts consistently, coherently, and credibly to their users can demonstrate here is a body of actions in which the consumers don't have bargaining power. That's an appropriate situation where the legislature should remove that body of actions from contract laws. Contract is not working in that situation. At least they can credibly do so. That's still a policy standpoint. The legislature will almost certainly get it wrong. But at least it's something that we can credibly say this is part of a democratic process, and it's been tested in the real world rather than simply in the abstract.
I have a comment to Professor Schmitz's presentation. I was very happy to listen about all the data you gathered in your research as to how consumers react or how they do not react. And I also deal a bit with trying to see what are the ways to make consumers act when they are supposed to act. So when, for example, they do services that do not respond to their expectations and so on. I just had a quick comment on the ODR system in Europe that you were saying that this is something that has been introduced and that might be something that the US could take as an example maybe in the future. Well, this is something new that we have, and we are still not quite sure how it's going to work out. Because, I mean, it has been debated a lot, and it was a compromise at the end, the rules that we got. So we are not quite sure whether this is actually going to convince consumers to make use of it, and whether it's going to be easy to use, and whether they're going to have incentive to use it, because we don't have any, like in most European countries, we don't have any sort of what's it called, class actions for consumers, which means that you still have a consumer who probably have little damage, maybe some sort of damage, and even if it's going to be easy to click on a button and start the whole
thank you for that comment because it's very, very apropos and astute. I mean, most certainly the difficulties come in the actual implementation. And in working on these different processes, I mean, when you think about security, there's how's it really going to work, the ODR, the directives, yeah, you're absolutely right. It's difficult because it requires the countries to create their own systems, but then it doesn't really give sort of enough guidance, and we don't know exactly how that's going to work, and will the standards be enforced, and will it be the same in each country? There's a lot of difficulties with that particular problem, and it's real interesting because you have that going on, and then you have this UNCTRAL process being discussed, which is very political and problematic, and you kind of end up with very odd bedfellows, as it were, and strange groups kind of agreeing and disagreeing. And then the EU, of course, is saying, well, we just put together our own process, so kind of you guys deal with your problem here. And so there's a lot going on with that, but it's a really big issue, and it's very hard for the ODR providers of Silicon Valley and some of these companies because they're going over to Europe and they're trying to sell their systems to all these different companies. And it's real, I mean, to the different countries, and it's real interesting to watch it all develop and see what actually will transpire. So that's a really good point. Yeah, it's hard. It's hard in the implementation and having consumers actually trust the process and platform.
One more question. Yes.
So this is sort of a question in defense of the public-private law a little bit. So in Mr. Keren's presentation, you had a slide where you said we have a right not to be exploited, and then so that's going to correlate with the duty of the state to protect us from being exploited. And I was expecting, well, we have a right not to be exploited, and that correlates with the duty of other people not to exploit us. It seemed like the natural way to go. And then when you look at a lot of the examples that many of you gave, I mean, I would think of these as just being private wrongs. These are people exploiting another person. It's someone doing another person a wrong. And I wonder if by thinking of it as a sort of serving a state end about inequality makes it more like progressive taxation and less like recognizing a direct wrong between two people. If there's almost something that gets lost there, if any of you are all worried about that.
I'm glad you raised that. So I think you're very right. I think that we kind of jumped to the response of the state facing a party that was exploited and a party that was exploiting the other party, right? So I'm glad that you're asking because in another paper I'm thinking about what are the steps that we can take to make people self-restrain themselves. So this is prior to this event that got to litigation. And I think that in this paper what I argue is really very important that judges will do this consciousness working of signifying what's moral and what's immoral, what's appropriate and what's inappropriate, not so much just for the very parties that are litigating in front of their face, or not only for legislation processes, but also due to analysis of how our illusions are working, and in order to articulate and define social norms in a way that will cause others watching the process to maybe out of anticipated guilt, out of many other possibilities, realize that this is not the way to do things and to restrain themselves. Now, granted that some people will cross those lines anyway, right? And then we'll